Listen to me. I don't think you're ignorant, man. I've already been told that you're a pretty smart guy. But if you let Eric Carroll get away with anything that us millions of people watch unfold with our own eyes, you can't deceive us, Lieutenant. You cannot deceive us.
A sentence like, "You cannot deceive us," sounds explosive when it's ripped from context and dropped into a circulating clip. It sounds like a threat. It sounds like pressure. It sounds like a line crossed. And that is exactly why discipline matters right now. Because this case does not exist in a vacuum. It exists in a space where a vulnerable family, an active fraud investigation, and an emotionally invested audience all collide. In that environment, a single unverified claim can do real damage, not just to reputations, but to safety, to process, and to truth itself. Right now, a video is being shared with an attached claim that it shows intimidation, possibly even threats, aimed at a judge and a lead investigator connected to the Whittaker fraud case. The framing is dramatic. The language is urgent. The implication is severe. But implication is not evidence. And the moment people stop separating what a video shows from what people say it means, the situation becomes dangerous. Not because of what's proven, but because of what gets assumed. So let's start clean. There is a real documented case. There's a real arrest. There are real felony charges tied to allegations of financial exploitation and fraud involving the Whittaker family. Those facts are grounded in the record. They do not depend on interpretation, tone, or clips. What is not grounded in the record, at least not publicly at this moment, is confirmation that a judge or a lead investigator has been formally threatened. That distinction is not technical. It is foundational. Because the moment someone claims a judge has been threatened, the consequences extend far beyond internet debate. Judges are not abstract figures. Investigators are not fictional characters. They are real people whose safety cannot be gambled with speculation. And when their names or perceived identities are floated online without verification, the risk does not stay hypothetical. That's why this conversation has to be disciplined. This is not about protecting anyone accused of wrongdoing. This is not about minimizing the seriousness of intimidation. This is about refusing to replace evidence with adrenaline. When a clip goes viral, people instinctively ask one question: is this real? But the better question is, what do we actually know? And what would we expect to see if it were real? That's where most conversations fail. They jump straight from emotion to conclusion. So here is what we refuse to do in this analysis. We refuse to declare that a judge was threatened without official corroboration. We refuse to treat a circulating clip as proof of intent. We refuse to fill gaps with certainty just because the narrative feels compelling. Not because intimidation isn't serious, but because false certainty is dangerous, especially in a case already saturated with attention. The Whittaker case has already drawn scammers, opportunists, and people eager to attach themselves to urgency. Every spike in confusion creates a new opening for fake fundraisers, fake legal defense pleas, fake emergency protection requests, and fabricated insider updates. These operations don't rely on facts. They rely on panic. And nothing fuels panic like the suggestion that the court itself is under threat. So before anyone shares, amplifies, or weaponizes a claim like this, there's a responsibility to slow down and ask, what is actually verifiable right now? That brings us to the video itself. Clips like this are designed, intentionally or not, for speed. They are short. They are emotionally loaded. They often circulate without timestamps, without original sources, without context, and without continuity. A sentence cut from a longer exchange can sound radically different when isolated. A jump cut can remove the qualifier that changed everything. A caption can insert meaning that was never spoken. And once that version spreads, the original context is nearly impossible to recover. This is why responsible analysis starts with what is observable, not what is inferred. Who is visibly on screen? What words are audibly spoken, clearly, without captions filling gaps? Is the recording continuous, or are there obvious edits? Is there a date, location, or identifying marker that ties it to a specific moment in the case timeline? Without those anchors, a clip can suggest almost anything. Then there is the second layer, claims made about the video. Sometimes the clip itself includes a voiceover or text asserting that officials were threatened. But a statement inside a video is still a claim. A caption is not a court filing. A creator's interpretation is not an incident report. A repost does not transform allegation into fact. And finally, there is the third layer, the most volatile one, audience interpretation. This is where certainty forms without evidence. That must be the judge. That's clearly intimidation. They're trying to influence the case. These statements feel convincing when emotion is high, especially when people believe they're defending a vulnerable family. But belief does not equal proof. And acting on belief alone can create the very harm people think they are preventing. So the disciplined position, the only responsible one right now, is this. A video is circulating with a claim attached. The claim is serious. As of this moment, there is no publicly verified official confirmation that a judge or lead investigator has been formally threatened. That does not mean nothing happened. It means we do not yet have the record to say what happened. And that distinction protects everyone involved. Because if a threat were credible, the system would not treat it as internet chatter. It would leave traces, paperwork, statements, procedural shifts, security responses, things that can be verified, which raises the next necessary question. Not whether the clip feels threatening, but what would we expect to see if it were? That's where this analysis goes next. In the next part, we will break down how verification actually works in cases involving alleged threats to officials, and what kinds of official signals separate rumor from reality. And until those signals exist, restraint is not denial. It is responsibility. When a claim involves intimidation of a judge or a lead investigator, the standard of verification rises sharply. Not because officials are above scrutiny, but because allegations of threats activate an entirely different legal and security framework than ordinary online disputes. This is where many internet conversations collapse. People assume that if something serious happened, it would instantly be public. In reality, the opposite is often true. But that doesn't mean nothing becomes visible. It means the visibility changes form. So let's ground this in process, not opinion. If a judge or investigator is credibly threatened, the response does not depend on public outrage. It depends on protocol, and protocol leaves footprints. The first footprint is documentation. Threats, whether direct, implied, or conditional, are logged. That logging can take different forms depending on how the threat is delivered. A phone call generates a report. A message generates a record. A video submitted as evidence is preserved. Even an in-person statement reported by witnesses creates a written account. This step happens quietly and immediately because preservation matters more than publicity. The second footprint is assessment. Not every heated statement qualifies as a legal threat. That distinction is crucial. Investigators and courts evaluate specific factors. Was a target named? Was there language suggesting harm or coercion? Was there an implied consequence tied to an official action? Was the speaker identifiable? Was there a realistic capacity to act on the statement. Context matters. Tone alone is not enough. This is where the internet often gets it wrong. Anger is not automatically a threat. Criticism is not intimidation. Even aggressive rhetoric may fall short of the legal threshold unless it meets defined criteria. That's why verification requires more than watching a clip and reacting to how it feels. The third footprint is procedural response. If a statement crosses into credible threat territory, procedures change. Sometimes subtly, sometimes visibly. Courthouse access may be adjusted. Security protocols may tighten. Communication channels may shift. In rare cases, hearings are rescheduled or moved. These changes are not always announced, but they are often referenced indirectly through filings, scheduling notes, or official statements. And this is where the absence of evidence matters just as much as its presence. As of now, the publicly verifiable record tied to the Whittaker case continues to center on alleged financial exploitation, fraud, and ongoing investigation. There is no docket entry, no prosecutor statement, no law enforcement release, and no reputable reporting citing named officials that confirms a judge or lead investigator has been formally threatened. That doesn't mean the video is meaningless. It means the video alone cannot carry the weight of the claim being attached to it. There is a difference between content that alarms and content that confirms. And confusing the two creates consequences. Because once people believe a judge has been threatened, behavior changes. Some escalate rhetoric. Others begin targeting perceived enemies. Some try to defend the court by attacking individuals they believe are responsible. This is how misinformation becomes operational. It stops being a story and starts becoming action. That's why restraint matters most at the exact moment emotions peak. Now let's talk about a common misconception. If there were a real threat, wouldn't we already know? Not necessarily, but we would see indicators. One indicator is official acknowledgement, even if limited. This can be as restrained as authorities are aware of in reviewing a matter, or as direct as confirmation that a report has been filed. Another indicator is procedural reference, a filing that mentions safety concerns, an order that restricts contact, or a change in access rules. A third indicator is verified reporting that quotes named officials and ties claims to documents, not speculation. What does not qualify as verification are anonymous posts, commentary videos asserting certainty, captions that claim insider knowledge, or repost chains that grow louder with each iteration. This distinction is especially important here because the Whittaker case is already a magnet for manipulation. Where there is vulnerability, there will be people who attempt to leverage urgency for influence or money. Claims of threats are powerful tools in that environment. They can be used to justify new fundraisers, to pressure audiences into acting now, or to delegitimize scrutiny by reframing it as intimidation. And that brings us to another uncomfortable truth. False or exaggerated claims of threats do not protect vulnerable families. They expose them to more chaos. They draw on more attention. They increase emotional volatility. They invite people who want to feel important by inserting themselves. All of that makes the environment less safe, not more. So what is the responsible posture right now? It is not disbelief. It is not dismissal. It is suspension of judgment until the record speaks. The disciplined sentence remains the same. A clip is circulating with a claim attached. As of now, there is no publicly verified official confirmation that a judge or investigator has been threatened. That sentence protects everyone. It protects officials from being prematurely named or targeted. It protects the public from being manipulated by unverified urgency. It protects the Whittakers from becoming collateral damage in another wave of attention-driven chaos. And it protects the integrity of the case itself. Because the moment a case becomes about alleged intimidation rather than evidence of exploitation, focus shifts. Attention moves away from financial records, from accountability, from safeguards for vulnerable people. It turns into spectacle. And spectacle is where truth goes to die. So before this conversation moves any further, one more principle has to be clear. Verification is not about silencing concern. It is about directing concern toward the right sources. If there is intimidation, authorities are the ones equipped to handle it. If there is no confirmation yet, restraint is the safest position. In the next part, we will walk through what would happen if a threat were deemed credible, step by step, so people understand how seriously such situations are treated and why guessing helps no one. Until then, the most protective action is simple. Do not name targets. Do not amplify assumptions. Do not share clips as proof of intent. Watch the record, not the noise. And if confirmation comes, it will come through channels that leave no doubt. To understand why verification matters so much, you have to understand how seriously the system treats threats against the court. This isn't YouTube drama. This is an influencer conflict. This is the backbone of the justice system, and interference with it triggers a very specific, very disciplined response. So instead of arguing over clips, let's walk through what actually happens when a judge or lead investigator is credibly threatened, step by step, based on how these situations are normally handled. Not hypothetically, procedurally. First, the moment a threat is considered potentially credible, the focus shifts away from public narrative and toward containment. Containment doesn't mean silence because nothing is happening. It means silence because talking too much can make things worse. When a threat involves a named official, the priority is preventing escalation, not feeding attention. This is why many people misunderstand the lack of immediate public statements. They think silence means dismissal. In reality, silence often means evaluation is underway. The first internal step is classification. Authorities determine whether the communication qualifies as a true threat, an attempt at coercion, harassment without threat, protected speech, even if aggressive. This classification is not based on vibes. It's based on statutory language, precedent, and context. Words matter. Intent matters. Capability matters. Audience matters. A statement like, "You'll regret this," may feel threatening to viewers, but legally it can be meaningless without specificity. On the other hand, a calm sentence that references timing, location, or consequence can trigger immediate escalation. This is why clips are dangerous without context. The sentence before and after often determines everything. Second, if a threat crosses the legal threshold, jurisdiction matters. Threats against judges and investigators can fall under local law, state law, or federal law, depending on who the official is, what role they hold, how the threat was delivered, whether interstate communication was involved. That means more agencies may quietly enter the picture. This does not always result in press conferences. Often it results in coordination. Third comes evidence preservation and attribution. This is the part people rarely see, but where the most work happens. Authorities preserve original files, not reposts, metadata, account histories, IP-related data where legally accessible, prior communications that establish pattern. This is why reposting clips, adding captions, or editing footage can actually make things worse. It muddies the evidentiary trail. It introduces distortion, and it makes it harder to determine original intent. This is also why responsible analysts refuse to speculate publicly. Once speculation becomes widespread, it contaminates witness pools and complicates attribution. Fourth is risk assessment and mitigation. If a threat is deemed credible, officials ask, Is the target currently exposed? Does the alleged source have proximity or access? Has there been prior escalation? Is there a foreseeable timeline? Based on this, security measures may be adjusted. These adjustments are not always dramatic. They can be as subtle as changed routes, altered schedules, or restricted access. Observers often assume that if security changes aren't obvious, nothing happened. That assumption is wrong. Many protective measures are intentionally invisible. Fifth is legal consequence evaluation. Threats against officials are not handled lightly. Depending on the findings, potential consequences can include new criminal charges, bond revocation if the individual is already under court supervision, expanded no-contact orders, stricter release conditions, additional monitoring, and this is critical. Courts do not need public pressure to act. If someone is already facing serious felony charges, even the appearance of intimidation can drastically alter how the court views risk. Judges are acutely aware of power dynamics, especially in cases involving vulnerable victims. Which brings us back to the present reality. If a credible threat had been confirmed, we would expect to see some trace of this process by now. Not gossip, not commentary, a procedural footprint, a filing, a condition change, a verified statement. So far, what we have instead is a circulating clip paired with escalating interpretations, but no confirmed procedural shift tied to intimidation. And that distinction matters because of what happens when the public gets ahead of the process. When people believe a threat has occurred, they often respond by trying to defend institutions. But defense without authority becomes interference. Naming alleged perpetrators, harassing perceived allies, flooding officials with demands. These actions don't help. They complicate cases. Worse, they can unintentionally create the very pressure environment that courts are trying to prevent. This is why restraint isn't apathy. It's alignment with how justice actually functions. Now let's address another common question. Why would someone even circulate a clip like this with such a serious claim attached? There are several possibilities, none of which require a grand conspiracy. One possibility is misinterpretation. People hear intensity and assume threat. They project meaning based on fear or loyalty. Another is narrative escalation. In heated cases, stories evolve to keep attention. Allegations grow more dramatic over time, not necessarily because facts change, but because outrage has a half-life. Another is opportunism. Claims of intimidation can be used to silence critics, paint scrutiny as persecution, generate urgency for donations, reframe accountability as danger. This is especially risky in cases where money, vulnerability, and public sympathy intersect. And then there's the most human explanation of all. People want certainty. They want villains and heroes. They want clarity in a story that is legally slow and emotionally heavy. But certainty without evidence is how misinformation becomes weaponized. So where does that leave us right now? It leaves us with a responsibility to hold two truths at once. One, threats against officials are serious and must be taken seriously when verified. Two, claiming such threats without confirmation can cause real harm to officials, to the case, and to the very people the public says it wants to protect. This is why the most important role the public can play is not amplification. It's patience. Watch for verified court filings, official statements tied to named sources, procedural changes that leave records. Ignore anonymous certainty, escalating captions, calls to action based on fear. In the next part, we'll zoom out and examine how claims like this, verified or not, affect the Whittaker case itself, and why distraction at this stage may be the most dangerous outcome of all. Because sometimes the biggest threat to justice isn't intimidation. It's noise. By the time a story reaches this point, the risk is no longer just misinformation. The risk is misdirection. And misdirection is one of the most effective ways to damage a serious case without ever touching the evidence. That's why this circulating claim matters, even if it turns out to be exaggerated or false. Because claims of threats against judges or investigators don't just add drama. They reframe the entire narrative. And when that happens, the focus shifts away from the questions the legal system is actually trying to answer. Those questions are simple, even if the case is not. Who controlled the money? How was it collected? Who benefited? What evidence supports exploitation or fraud? What protections were violated? Everything else is secondary. But when a story becomes someone threatened the court, the center of gravity moves. Suddenly, the case isn't about alleged exploitation of a vulnerable family. It becomes about institutional danger, about intimidation, about chaos. And once that shift happens, the Whittakers stop being the protected party in the public imagination and start becoming background noise. That's not accidental. It's a pattern. In high-pressure cases, especially those involving online audiences, there is a predictable sequence when things get uncomfortable. First comes scrutiny, then comes denial, then comes counter-narrative, and finally comes escalation. Escalation often takes the form of claims that the system itself is under attack. Why? Because attacking the system reframes accountability as persecution. If investigators are being threatened, then attention moves away from the allegations and towards sympathy for authority. If a judge is under attack, then procedural delays or silence can be reframed as fear rather than due process. And if people believe the system is compromised, they're more likely to distrust outcomes that don't align with their expectations. This is why disciplined reporting matters so much at this stage. Because once public confidence in the process erodes, everything becomes harder. Witnesses become reluctant. Agencies become quieter. Courts become more guarded. And vulnerable families become more isolated. Ironically, the people most harmed by narrative chaos are often the very people everyone claims to be protecting. Now consider the Whittakers' position in this moment. They are already at the center of a case involving alleged exploitation, public fascination, and state intervention. Their lives have been scrutinized, filmed, discussed, debated, and monetized. Their privacy has already been compromised beyond what most families ever experience. In that context, a new explosive claim doesn't land in a vacuum. It lands in a fragile environment. If the public believes officials are being threatened, what happens next? People start investigating on their own. They start naming suspects. They start sharing addresses. They start contacting offices. They start flooding officials with messages. They start defending the case by attacking perceived enemies. None of this helps. In fact, it triggers the opposite response from a system. When pressure spikes, agencies pull back. They lock down information. They limit communication. They protect personnel. They reduce exposure. They stop answering questions that aren't strictly required. Transparency decreases. So if someone genuinely cares about accountability, this is the worst possible outcome. The truth is uncomfortable, but needs to be said plainly. Chaos protects the wrong people. Chaos delays cases. Chaos muddies evidence. Chaos creates excuses. Chaos allows everyone to argue about side issues instead of facts. And in some cases, chaos becomes the defense. That's why responsible analysis refuses to inflate unverified claims. Because once the narrative turns into the system is under attack, the defense doesn't have to argue facts anymore. They argue fairness. They argue safety. They argue public hysteria. And suddenly the case isn't about evidence. It's about atmosphere. This is especially dangerous in cases involving alleged financial exploitation, because those cases are built on paper trails, timelines, and intent. They require patience. They require clarity. They require careful reconstruction. Noise doesn't expose fraud. Noise hides it. There's another consequence people rarely consider: donor manipulation. When a case feels urgent and dangerous, scammers thrive. Claims of threats create urgency. Urgency bypasses skepticism. And suddenly you see new fundraisers, emergency legal funds, protection drives, relocation funds, all framed as necessary right now. This is exactly how vulnerable families get exploited a second time. People mean well. They act fast. They don't verify. And money moves into the wrong hands again. This is why every responsible voice in a case like this keeps repeating the same instruction: slow down. Now let's address the emotional pull behind this clip. The line in the video that's circulating feels powerful because it taps into a shared frustration. Many people genuinely believe they watched wrongdoing happen in real time. They feel dismissed. They feel unheard. They feel like justice is slow while harm was immediate. Those feelings are understandable, but feelings are not evidence. And more importantly, feelings don't authorize escalation. The legal system does not respond to collective outrage by bending rules. It responds by enforcing them more strictly. If officials are harassed, even unintentionally, judges don't speed up. They restrict. Prosecutors don't explain more. They say less. Investigators don't engage publicly. They document quietly. That's the reality. So what should people actually be watching for right now? Not clips, not captions, not claims. They should be watching for signals that come from the system itself. Has there been a change in court scheduling? Have bond conditions been modified? Has a filing referenced safety concerns? Have reputable outlets reported an official acknowledgement? Have named officials spoken on record? These are the only indicators that matter. Anything else is speculation, and speculation has consequences. It's also important to understand this. Courts are extremely protective of judicial independence. Allegations of intimidation are taken seriously precisely because they threaten that independence. That means courts are cautious about public acknowledgement unless it's necessary. So if something were credible, it would be handled with gravity, not theatrics. No dramatic leaks. No viral back and forth. No social media commentary. Just procedure. That's not a cover-up. That's how stability is maintained. So here is the hard line that responsible coverage draws. Until there is documented, official confirmation, the claim remains unproven. That doesn't mean dismissing concern. It means placing it where it belongs, on hold. Because the alternative is worse. The alternative is a case derailed by noise, a vulnerable family pushed further into instability, and a justice process forced to operate under pressure it never asked for. And that would be the real tragedy. In the final part, we'll narrow everything down to the single verification point that ends the debate completely, one way or the other, and explain how to recognize it when it appears so no one has to guess, speculate, or escalate. Because the truth doesn't need volume. It needs proof. Thank you for watching this video. Click here to watch another video that might interest you.